necessity for the project and for let me moderate this panel. As you already know, I'm a public prosecutor. As for the situation in Spain, we have a very good relationship, a close relationship with our Aro and Amo. They are together in organism called Orga, but we don't have any role inside the Orga. Then maybe it's a signal of the necessity that the prosecution office take a more important role and maybe detach experts, as in France, my colleague Arnaud, into the Orga. Okay, let's start with Mr. Edward Levi from the ANABI, also like in Spain is Aro and Amo together. And he's going to talk about the role of the Asset Recovery Office in the new directive. We should, okay. One? Oh. Ah, la computadora. Okay. Ah, vale. Vale, vale.
Good morning. My name is Eduard Levi. I'm a judge. I'm a judge in civil matters for 8 years and seconded in the Aro and Amo offices in Romania, ANABI. Why I participate as a civil judge at the criminal activity, criminal procedures and in this area? Because yes, indeed, we are in a framework of criminal procedure, but when you talk about money, when you talk about management of the assets, when you talk about assets in general, it's about civil law. So this is why in Romania I will try to encourage some civil experts to be part of our project in ANABI and other cooperation in a criminal matter, judicial cooperation in criminal matter. Thank you very much, Professor, for the opportunity and for this occasion to express our knowledge about AMO and our activity. So we at ANABI have, like to say, a one-stop shop. We have ARO, AMO, we have an electronic system, electronic register about assets which are seized and confiscated. We do asset sharing agreements, social reviews. We have a mechanism to support the crime prevention, and also we have activities in the policy, in criminal policy. I will refer today about ARO activity and about the new directive and the powerful arrows from the new directive. Yes, we talk about arrows very much during criminal investigation, but the activity of arrows, even it is completed after we share the information. We also have a important activity after the conviction as a post-conviction activity. So firstly, I will talk about the asset tracing activity. And in the post-conviction, we will talk about the asset sharing agreements and how we trace the assets after the confiscation, if we need to find them in other jurisdictions. General aspects about the new directive. The new directive and regulation will be the most powerful instruments in the judicial cooperation. In time, the framework of the new directive will be as substance because they will empower the ROs and AMOs in time in which the regulation will assure the framework where these powers will be exercised. As you know, every member states will need to have an RO, which now they already have. It's another instrument, but we need to have new powers at RO. In my opinion, ROs in the directive will need to have this triangle of activity. First, in the base, it's Article 6, because the Article 6, it's about data. If we don't have the data, the proofs, we will not have asset seized, you will not have a confiscation, you will not have a conviction. So the main activity is about the proofs and the information. After that, after you will have the information, you can share with others on the base of Article 9, and also you can do it more from what you have now. You will do immediate measures. You will have to freeze the assets and cover a gap from our legislation, which is now at the cooperation, international cooperation level. So about the Article 6, want to say that it is a distinction, of course, between judicial cooperation, police cooperation, and this distinction is also about data information, police information, and proofs. This is the essential, and it was a debate, a very long debate at the negotiations. In our view, the importance of the information is crucial, in particular for the preparation of the specific procedures for judicial cooperation in criminal matters. It has thus been observed that many member states easily implement forms of judicial cooperation, particularly when we are talking about European investigation order, if the specific procedures for exchanging information or personal data through the RO structure have been followed beforehand. So the Article 6 will it's already done. The Article 6 presents all the database which will be accessed by ROs. There are quite important database like National Immovable Property, National Register of Citizenship, National Register of Motor Vehicles, business registers, National Register of Beneficial Owners, data about the assets. Of course, the important data are the Article 6, paragraph 3, fiscal budgetary data, national social security data, and relevant information held by competent authorities, because there will need extra protection, these three types of data. And also at Article 6, paragraph 3, it's another types of information about the mortgage and loans, information contained in national currencies database, information of securities, and other information about the transit in the European Union. The link between 6 and 9. After we will have this data, we need to share with other ROs from another state members. That is the main activity, because the ROs for the national activity maybe will not be so significant. Already, judicial bodies, police bodies, they already have access to all the database, and it will be in very limited cases when they will ask RO to provide something for the national file. But when you have an international activity, when you want to find the assets in European Union, you will have to ask AROS for help. So in this matter of international cooperation, Article 9, it's about the sharing of this data and proofs. In our opinion, it was better as in the first scenario of the Commission that all the data to be used as a proof, because in our opinion, it was an objective data, objective information. The AROS only access some registers and will inform other AROS about this information. It will not be modified. It's not a perception. It's only an access. But now this access it need to have a not opposite. The state members who will share the information need to say that he don't post to use as a proof. But if it will be an opposition, you need to double this activity as a European investigative order or another judicial cooperation, even if you will obtain in the end the same information. But it will be better because you already know something and you will only double that information. I will talk more about the safeguards and a system to use this information as a proof. In my opinion, there are 3 levels of safeguards in accessing the database. They are at Article 9, paragraph 6 and Article 6, paragraph 5 and 6. First, at Article 9, when you cooperate between AROS, you'll have a safeguard that asset recovery offices may refuse to provide information to a requesting asset recovery office if there are factual reason to assume that the provisions of information would harm the fundamental national security interests of the member state in which the asset recovery office receiving the request is located. It will be affecting an ongoing investigation or criminal intelligence operation, or pose an imminent threat to the life or physical integrity of a person, or be clearly disproportionate or irrelevant with regard to the purpose for which it has been requested. Or firstly, I need to, when AROs will be asked from another ARO, will have this examine, and the ARO which is requested, if identify one of these cases, it will reject the request. After that, we have the level 2. After we accept to interrogate our base, if the national state on the Article 6, paragraph 5 established some protection, supplementary protection, member states may decide to access the information referred in paragraph 3, point ABC, which are fiscal budgetary data, national social security data, and relevant information held by competent authorities for the prevention, detection, investigation, or prosecution of criminal offenses. So when you are on this basis, the member states can also establish at the national level another exam to request. Such a request can be denied where the provision of the requested information would affect the success on ongoing investigation, be clearly disproportionate, and compromise information provided by another state members. So when the ARO, national ARO, which is asked to share the information, will have to access this database on the national level, the national state can establish another filter, another condition on these three provisions. And the last one, which is the most powerful in my opinion, the Article 6, paragraph 6, access to information to referred in Article 6 can be without prejudice the procedural safeguards established under the national law, including where necessary the requirement to obtain a judicial authorization. So, in my opinion, this is the image. The prosecutor from the state one will ask ARO from the state, from national ARO to obtain the information. They, if in the national law need to be a special authorization, for example, balance accounts, the prosecutors need to have this authorization. So it need be respect the Article 6, paragraph 5 and 6. After that, the ARO from the state 1 will ask the ARO from the state 2. The ARO from the state 2 will examine the first solicitation as in the respect of Article 9, paragraph 6. So it can be rejected as international cooperation. After it will be this filter, if the information from the database, fiscal budgetary database, for example, from the state 2, needs a special authorization from a judge or a prosecutor, the ARO need to ask this authorization from the judge, from the national judge, and after he will obtain and will access the database, budgetary database, this is the problematic one. After that, we'll share with ARO from the state one, and ARO in the state one will share it with the prosecutor who was the first who want that information. And if it is it will be respected, all these 3 levels of safeguards. I think it will not be a problem that the data will be shared as a proofs. That's the importance to work together, and maybe it will be an important activity for AROs in our judicial network, on our networks, to establish each of ARO, which is the condition for each register from Article 6, maybe in another European project. So you know that in Romania you don't you don't need a special authorization for the real estate database, but you need a prosecutor authorization to know the accounts, and you need a special authorization from the investigative judge for balance of the accounts. So if you are in Germany, and if you know what are the special authorization to Romania, you will need to respect and to try to obtain and inform our Romania. You need to obtain this authorization, and we want it because we wanted to use it as a proof. And of course, you'll need to, in Germany, for example, you need to also have an equivalent if you need special authorization to respect that requires also. To complete our triangle, it's about special activities on immediate measures. So we'll have the information, we'll have the sharing information at Article 6 and 9, but after that, we'll need to cover a gap between before recognition under the regulation 1805. That was the problem. It was a lot of time spending with this police or judicial cooperation until you will recognize the seizure order under the regulation. And if the gap, it was a long time, 3, 7, 1 week, the assets from the asked state will disappear, because you can sell now or have a wire transfer in seconds. So with immediate actions, all the arrows from European Union the international cooperation will need to have these powers. I don't think there are there are states which have already such powers. We don't have in Romania, so we need to transpose this power. But after this triangle will be completed, I think the judicial cooperation and police cooperation will be effective and maybe more productive from that is now. In our perspective, arguments in favor of granting also jurisdiction for our own matter of immediate measures is in international cooperation were the following. Firstly, administrative barriers caused by inability of the competent bodies in different member states to communicate will be avoided. RO structures have over time developed a secure and constant channels of communication, which is a real advantage in providing assistance as quickly as possible. Secondly, the RO has access to the national register containing data and information on assets in accordance with Article 6 on the directive, and the freezing of these assets for a short period of time could be carried out immediately, precisely as a result of uniform procedure carried out by a single institution. If the asset information is in any case provided by the RO structures on the basis of Article 6 and Article 9, taking immediate actions on the asset just identified is the option that ensures the greatest coherence of the whole architecture underpinning an effective financial investigation. About RO Romania, because about AMO in Romania will be the presentation of my colleague. This is the state which we collaborate. It's a CARIN network, and also other networks, but at CARIN network we are with green. There are the best practices there. We had been asked by 44 jurisdiction, and for 78 jurisdiction we already sent information. Until 2023 there was about 2,000 auto vehicles, 5,000 bank accounts, 2,000 real estates identified by RO Romania. About the post-conviction activity, yes, I repeat, maybe ROs are more visible in the first phase of criminal proceedings, in the investigative phase, but I think there need to be more powerful also in the enforcement phase. In Romania, we have the power to submit the matter of the execution court regarding to the procedure for recognition of an equivalent confiscation order, special or extended confiscation order. So if the national court will have a confiscation order on extended confiscation, special confiscation, or maybe the new type of confiscation from Article 16, and we, in our cooperation, will have the data that some assets of the affected person, they are in other member states, we can form a request to the for the court, for the execution court, to have the to prepare to recognize under the regulation 1805 the confiscation order. Maybe the court at the final trial they didn't know about the assets from other member states, but in the execution phase we find these assets, and the court ex officio, the courts will not do it. They need to be asked about that. And in Romania, we have competence. Also, as an activity, as an RO, ANABI has the legal authority to negotiate and facilitate the conclusion of asset sharing agreements. we have this 50-50% in the regulation 1805. For example, I think in the weeks, 2 weeks, we'll have an asset sharing agreements with Italy over 100,000 euros. It's not much, but it will be done. From our perspective, a recommendation in this matter is to establish, every member state to establish very clearly which are the competent authority to have to do these asset sharing agreements, because we had some problems to identify these authorities in member states. And we also recommend that more extensive provision of this matter be carried out, for example, for the simple freezing and confiscation of the sum from a bank account in which a substantial sum is located. It may sometimes seem unjustified to retain 50% by the state of execution. Maybe this competent authority will be more open to negotiate effectively, not to establish this 50% of the assets. So this was my presentation, and also I and Alice will have a short video at our final presentation, but maybe the person from the back will come in front of the in front of the court. Because it is in Romanian, the video, and we'll have the translation in English as a subtitle. If I have time, if I don't have the time, 5 minutes. Okay. After? Okay. After only one video. After.
Good day, everyone. My name is Alice Cutaruș. I'm an asset tracing and management inspector within ANABI. First of all, as we conclude the cover project, I want to address a special thank you for Professor Maugheri and also for all the partners. This project has been a valuable learning experience, and I want to thank you all for that. As for my topic, today I will speak about asset management and protection of third parties. And I will begin by saying that in Romania, according to our national law, ANABI is appointed as a national office for the management of seized assets within the European framework. ANABI was set up in 2015 and is a part, as we already said, of the National Agency for the Management of Seized Assets. The mandate of the AMO is to ensure that the seized assets are effectively managed, maintain their value, and preparing them for eventual interlocutory sales in accordance with legal and procedural requirements. AMO also is responsible for temporarily storing and managing seized movable asset with high value. AMO also administers and records the amounts of money that are subject to seizure under our criminal procedure code. AMO is authorized to sell movable and immovable real estate assets during criminal proceeding by interlocutory sales under specific legal conditions. For that, AMO organized a online public auction for movable assets and physical auction for immovable assets. AMO also supports judicial authorities by providing them expertise and best practices in order to seizure and to effective management of assets that are subject of confiscation. AMO manage also the National Integrated IT System, which is called ROARMIS, that goes from Romanian Asset Recovery and Management Integrated System for recording claim derived from crimes, ensuring transparency and accountability in the management of seized and confiscated assets. AMO also facilitates the reuse of confiscated real estate for public and social purposes by transferring it to public institutions or to NGOs in accordance with legal regulation. As an overview, here are the assets that are currently managed by AMO, ANABI. We have over 35,000 bank accounts with a total of a lot of euros. Okay, we have also movable assets under our administration. We have cars, watches, motorcycles, and from 2018 we also have virtual currencies. We have more than 35 types of cryptocurrency that we have in our administration. If you want to see our assets that are storage in a secure deposit, you'll see the cars, you'll see also the watches, the stocks. As for interlocutory sale, in our national law, during the criminal proceedings, the interlocutory sales can only be made according to a decision of a prosecutor or a judge. We have some conditions. If the defendant gives his consent, we can sell his assets, but if he doesn't if he doesn't approves with that, we have special conditions under our criminal procedure code. If the asset decrease with at least 40% compared to the time of enforcing the asset freezing, where there is a risk of expire of the guarantee, or when the distraint was applied against livestock or birds, when the distraint was applied to flammable and petroleum products, when the distraint was enforced against goods or that storage maintained involves disproportionate expenses, and when the distraint, the seizure was applied to a stock of goods or products with a over 3,000 euros value. Also, during the trial, we have a special case. Sorry, we have a special case when the to sell the car when the owner couldn't be identified and the sale cannot be performed. Vehicles that are subject of a freezing order may be sold in the following cases: when they were used in any matter in the commissions of the offense, if a time period of 1 year or more has passed since the date of ordering asset freezing against such type of asset. I will also speak about online auction. Okay, Last year, we have 52 public auctions, within which the agency sold assets such as cars, trains, raw materials, electronic equipments, and jewelries. As a novelty, Anabi received also gold jewelry and work of art, paintings, and watches. The money conversion rate of movable assets is 107% by reference to prices of the start of public bidding, as established in the response made by an expert evaluator. Online auction portal was made by Anabi during the pandemic, and is portal that ensured continuous and transparent selling of these assets. We have the portal attracted over 300,000 unique visitors. Okay. For the first time, we sell even a real estate asset last year. And we have also a premiere. We sell a Baltic amber from smuggled contraband that was seized by the prosecutors, recovered by Anabi, and was exposed at a national museum. This is our online portal where you can see the cars. As for the public and social reuse, Anabi, as I said before, has a competence in public and social reuse of immovable assets. We have a success case this year. A building was entered into the private property of the state through confiscation and was transferred free of charge for social reuse from the private domain of the state to a private domain of a country commune, and it was to establish a settlement for the elderly. We have also a mechanism for supporting crime prevention. Is our is a tool that it's an institutional and financial tool that aims to prioritize the allocation of resources for implementing activities and project focuses on legal education, crime prevention, and victim assistance. As I said before, we have RoArmis, which is our unique electronic register, where you can see all seized and confiscated assets, the entire life cycle. Anabi is also part of the PCRAC of Council of Europe, which is a committee of experts on the recovery of assets. And PCRAC it's working on the additional protocol to the Convention of Varsovia on money laundering and financial terrorism, and the core aspects that are in this regard is to improve sharing of confiscated assets, management of seized and confiscated assets, non-conviction-based confiscation, extended confiscation in criminal matters, and cooperation regarding an execution of request and confiscate decision in transnational cases. As We will put the video. I forgot to speak about the protection of third parties. We in Romania we have a specific procedure to protect the right of third parties when asset is seized or confiscated. This measure ensures that people who are not involved in criminal activities but have a legitimate claim to an asset are safeguarded. They are noticed before a trial. They can offer in front of the court proofs to demonstrate their ownership about the assets, and they can contest the decision if the assets are seized or confiscated.
Care justiția se confruntă cu provocări complexe, rolul ANABI este esențial în oferirea de suport organelor judiciare. Acompaniați-ne într-o călătorie prin activitatea angajaților ANABI. Vom descoperi provocările, dar și oportunitățile de a face diferența în lupta cu formele grave de criminalitate. Fiecare detaliu contează în lupta împotriva criminalității și recuperarea activelor. Specialiștii ANABI își încep ziua cu o ședință de strategie, analizând dispozițiile primite de la organele de cercetare penală. Ei planifică și redactează solicitări către oficiile de recuperare a creanțelor sau autoritățile cu atribuții similare din alte state membre ale Uniunii Europene, în scopul identificării bunurilor provenite din săvârșirea de infracțiuni și a altor bunuri având legătură cu infracțiunile, care ar putea face obiectul unei dispoziții de sechestru sau confiscare. Pe teren, acțiunile sunt rapide și precise. ANABI acționează cu precizie și profesionalism, respectând întotdeauna dispozițiile organelor judiciare. Coordonarea cu autoritățile judiciare este esențială pentru succesul procedurii. O echipă ANABI, la solicitarea procurorului sau a instanței de judecată, preia în administrare bunuri mobile sechestrate cu valoare individuală de peste 15.000 de euro, precum mașini de lux, opere de artă, ceasuri, dar și stocuri de bunuri cu valoare de peste 300.000 de euro. Administrarea bunurilor sechestrate necesită atenție și expertiză. Fiecare bun este evaluat și depozitat temporar la ANABI în condiții de siguranță. Încă din 2019, la solicitarea organelor de urmărire penală, ANABI preia în portofelul electronic inclusiv criptomonedele sechestrate în dosarele penale. Atunci când sunt îndeplinite condițiile speciale prevăzute de lege, criptomonedele sechestrate pot fi valorificate pe site-ul de licitații al ANABI. Un aspect esențial al activității ANABI este valorificarea bunurilor sechestrate. Acest proces se realizează din dispoziția organelor judiciare, cu respectarea dispozițiilor legale și contribuie la recuperarea creanțelor provenite din infracțiuni. Specialiștii ANABI manifestă atenție în fiecare etapă a licitațiilor, de la evaluarea inițială a bunurilor până la finalizarea valorificării bunurilor sechestrate. Procesul include atât bunuri mobile, precum vehicule și bijuterii, cât și imobile, cum ar fi proprietăți și terenuri. În era digitală, tehnologia este un aliat de nădejde. RoArmis este un instrument vital în urmărirea și administrarea eficientă a creanțelor provenite din infracțiuni. Angajații ANABI dedică o parte din timp pentru a lucra cu sistemul informatic RoArmis, actualizând și verificând datele privind creanțele provenite din infracțiuni. Acesta este un aspect crucial pentru eficientizarea procesului de recuperare a activelor. Colaborarea internațională extinde orizonturile ANABI prin parteneriate puternice. ANABI își extinde capacitatea de a combate criminalitatea. ANABI este parte din consorții internaționale și implementează proiecte europene fanion, împărtășind cele mai bune practici cu omologii străini. După înregistrarea în RoArmis a hotărârii de recunoaștere a Ordinului Internațional de Confiscare, specialiștii ANABI inițiază dialoguri cu omologii din străinătate și redactează proiecte de acorduri bilaterale de partajare a bunurilor confiscate. După finalizarea procedurilor de negociere cu aprobarea Ministrului Justiției, agenția încheie acorduri bilaterale de partajare a bunurilor confiscate. Prevenirea criminalității și sprijinirea victimelor sunt la fel de importante ca și lupta împotriva infracțiunilor. Prin Mecanismul Național de Prevenire a Criminalității, ANABI joacă un rol important în susținerea proiectelor care vizează sprijinirea victimelor infracțiunilor. ANABI sprijină implementarea Mecanismului Național de Prevenire a Criminalității, analizând propunerile de proiecte de la ONG-uri și planificând modalitatea de distribuire a fondurilor pentru educația juridică, prevenirea criminalității, asistența și protecția victimelor infracțiunilor. Prin PNRR, Ministerul Justiției și ANABI au asigurat resurse financiare suficiente pentru a garanta sustenabilitatea și dezvoltarea infrastructurii fizice și informatice care sprijină activitatea de recuperare a produsului infracțiunii. Astfel, cele 14 milioane de euro din PNRR sunt destinate dezvoltării infrastructurii fizice prin construirea a 5 depozite ANABI moderne, precum și pentru dezvoltarea versiunii 2.0 a RoArmis, dar și a site-ului de licitații online ANABI. Fiecare zi se încheie cu reflexii și planuri pentru viitor. În lupta împotriva criminalității, specialiștii ANABI rămân vigilenți, dedicați și mereu pregătiți. ANABI. Identificare, administrare, reutilizare. Proiect cofinanțat din Fondul Social European prin Programul Operațional Capacitate Administrativă 2014.
Thank you very much for your presentations and your video. I would like to arise some questions in the debate, but maybe it's better than the other intervenants intervene, and at the end, after Arnaud Deleguiche, I'll try to arise some questions. Then now is the turn of Mr. Inganghi, a national member for Italy, who is going to talk about the protection of the victims between seizure and confiscation. You have the floor.
Yes, because I forgot the procedure, actually. Okay, anyway, thank you for giving me the floor. When I read the flyer, I got at this table. My intervention is focused on the protection of victim right in education, seizures, conflict. But taking into account that recovery can mean so. My intervention is and also in this area. Why the topic is, in my opinion, always more and more important. I don't know. Yes. Thank you. Why it is so important? Please have a look to this slide. It represents the breakdown of Eurojust registration in 2024, from January to October 2024. You see that the most relevant part of cases dealt with by Eurojust, 1,406 cases, are related to swindling and fraud. They are all cross-border crimes, cross-border cases. And within swindling and fraud, we can say that it is a cluster which is composed of principally of love scams, finally hard scams, computer frauds, mail-in-the-middle frauds, and fake investment frauds. So all crimes where there is a victim, generally a natural person or a legal person, a factory, who resides in a country, in a European country, with the perpetrator who is in another country, and money flows who goes from the country of the victim to a second, third, and possibly fourth country. Is a figure that is completely different from what was the situation just 6 or 7 years ago, when the agency's efforts were dedicated to tackle OPG, drug trafficking, and PIF crimes, and shows a real emergency. An emergency that should be declined not only in terms of investigative measures, but also in terms of activities to ensure the restitution of and restoration of the damages suffered by the victims. Because these are crimes that, yes, they are a miscellanea of crimes that affect a lot the health, the wealth, and the business survival of the victims that are interested and hit by this crime. Hence, the need of the adoption of cooperation, international cooperation tools for freezing an asset, not only with the view to their confiscation, but even with a view to restitution and use of this wealth of these assets for compensation. But this is something that is not typical of the judicial tools that have been implemented so far with the European Union. 24 years of history in judicial tools for compensation. The first one talks about the right to restitution and compensation of the victim is the Convention of 29th of May 2000, with a provision which gives to the practitioner a weak weapon. Let's see Article 8.1 and point out your attention towards the request of a member state. The requesting member state may place articles at the disposal of the requesting. This is the first legal provision in terms of protection of victims within the criminal proceedings in criminal matters, in which, as I said, the position of the victim is taken down. What are the limits? The possibility for the requested state to return wealth, goods to the victim was optional, not binding. So the request from the requesting state. So no obligation from the state. Again, the provision was tailored only for restitution of properties directly derived from the offense. Hence, with the explicit exclusion of compensation. The referral is to the word articles, which means can be interpreted only as the restitution of asset is directly derived from crimes. And so, for instance, a painting, a real estate, but not, for instance, money, especially when money merged in bank accounts that contain other than the money which comes from the committed crime. And again, the possibility to ask for restitution and not for compensation, because provision doesn't allow, is entrusted the request of the requesting state with no provision for direct intervention for restitution to the victim. So there is still no indication of the possibility for the victims to act in a proficient way in order to trigger within the national protection of the requesting state or in the proceeding of the cooperation proceeding of the requesting state to claim for restitution or compensation. So what were the major difficulties we had to counter with this convention, which is a child of its time? The problem of restitution when the deeds of crime were no more articles, but were transformed to something else. Let's think, for instance, cases in which the proceed of a crime, the predicate offense, is transformed to something else, which becomes the proceed of a laundering activity, so of a money laundering, where the victim for the victim, and where the object of the possible restitution is no more article that was which derives from crimes. And in any case, in these cases, the possibility of the victim to be restored pass through complex and always expensive civil routes. And there was no possibility of granting rights to restitution, no matter of compensation, within criminal procedure. After that, the situation stands as it is, also in 2003, when the framework decision on freezing property enters force. With its Article 3.1, it states that the framework decision is issued only, I should say, for the purposes of subsequent confiscation of property. There is no room, no consideration of the rights of the victims to restitution. We cope with this problem at Eurojust. These are the outcome also of the first report on money laundering and asset recovery drafted by Susanna in this case. And we try to find with the existing tools possible solutions to allow restitution to at least restitution of assets. In which forms? Restitution within a parallel investigation secured by a member state. We know that when a judicial cooperation tool is requested by a member state, the other member state has to execute the requested assistance if the conditions are met. But in case the situation shows that there is a crime also committed in the requested state, they can open a parallel investigation. So the solution was, for instance, predicate offenses committed in member state A, transformation of the proceed of crime something else with the money laundering in the member state B executing state. So the restitution to the victim could be applied upon an initiative of the member state B country with its own dealing. So an indirect form of restitution using, customizing the opportunity given by the judicial cooperation tools that were not actually thought and tailored for such a Otherwise, the solution that we found, the parallel issuance of freezing order according to the framework decision and letter of rogatory aimed, targeted not only, and I underline not only, because that could be out of the scope of the MLA request, to investigative measures, but also to restitutions to victims of the original crimes. But in 2023, 2024, 2020, when we have to cope the numbers that I have highlighted you have seen in the first slide that I showed, we understand that the tools that we had at our disposal before the regulation were too weak, inappropriate, and not up to date in order to assure the recovery of the damages suffered from. And so very welcome to the regulation 2018-1805, where the victim's rights for the first time are taken in due account. I can see in the best account possible, but anyway in a due account. Recital 45 states, for instance, that restitution to the victims is a priority with regards to compensation with regards to possible confiscation and sharing of confiscated assets between requested and requesting country. So, victims first, the right of the victim prevails, the right of the state to confiscate does not prevail anymore. It's a change of mind, it's a change of strategy, it's a change of consideration of the institution of confiscation. All the previous cooperation tools were designed, tailored on the assumption and on the significance that in all EU countries, but all over the world, we give to the concept of compensation, of confiscation as a penalty, confiscation as a preventive measure. In this case, the regulation states, okay, in the path from the freezing to the confiscation, there is an internal intermediate step where we have to consider also the condition, the position, and the rights of the affected person, of the victims, not of the affected person. And the regulation allows also, with its Article 29, the possibility of compensating, restoring the rights of the victim before the final decision and pending the criminal proceeding and the freezing order. And what else? Always in the recitals of the regulations, it is clearly stated, I underline clearly, but unfortunately, it's not so clear when it comes to the actual application of the regulation, as we see in a Eurojust case law, that the right of property of victims almost always prevail of the right of a property of the third persons concerned. And we will see how and when, except for the case of bona fide third party. So what is on the balances when it comes to the restriction of illicit profits or crimes? And now I don't talk anymore of articles. I talk of properties as defined in the same regulation, which entail properties that can be returned to victims as a restitution, or as when the item to be returned is exactly the proceed of the crime, or as a restoration, which is it has been transformed to something else, which was not considered in the previous legislation, and so the instrumentalities of the crime, the goods in which the original assets were transformed in, and the profits of the same assets that were derived after the deprivation to the victim. What are the, if we consider that the principle is that the good, the proceed of the crime, the property has to be returned to the victims, the regulation explained what are the issues at stake in terms of a contrast with the property of third parties, and states the rule and the priority. So not all the rights of the affected person can be taken into account. The rights that have to be taken into account at any case are the right to defense, as designed, as provided for in the Charter of Nice. So the possibility, both in the case in the requesting country, both in the procedure of judicial cooperation in the requesting country, to apply file effective remedy, Article 47.1 of the Charter of Nice, the right to a fair trial, Article 47.2, and in general, the right of defense. So the procedural right to a correct procedure before the restitution of the goods to the victims as alternative to a confiscation. But what about the property of the third person concerned by a possible decision of restitution before a confiscation or at the end of a confiscation executed on the basis of the regulation? The right of property. Recital 40. Not all the forms of right property of the third person are protected. The right of property of the lawful owner, original lawful owner of the article, of the good, of the deed, of crimes, always prevails, except for the case of bona fide owner. So, no matter of discussion, but we have to discuss it in Eurojust case because it's not always so clear. No matter of discussion when the property has been purchased on the principle of usucatio, when the time 10 years passed, when there is when the system of the requested state taken a different consideration the aspects of due diligence, when the asset has entered in the property of the person concerned because it's an heritage of persons passed away. At this point, the regulation is very, very clear, but not at the same time very, very respected. Only when it comes to bona fide right, the action for the restitution is barred. Why it is so important? And what's the change of speed between the situation before the entry into force of the regulation and the tools we had at our disposal before? Let's see at this figure. These are the particularities of the Eurojust caseload in 2020. Let's remember that the regulation entered in force, became active in December 2020. So it's a bit blurred, but the area of asset recovery, which included both the tools, so freezing and confiscation of assets, we counted 99 cases of proceeding dealt with by Eurojust this particular. Let's see what happens today. There is same particularities from January to October 2024, so 10 months only 10 months and not 12. In this 10 months, we have opened Eurojust 235 cases related to the application of the regulation. It's more than a double. And it is in the if you do the breakout of this year, of these clusters, we see that an important part is regulated is devoted to freezing and confiscation in typical more relevant crimes for the public opinion as drug trafficking or OCGs, complex schemes of money laundering. But sometimes some of these cases, especially as far as, for instance, the Baltic countries are concerned, because they have a very efficient system for the detection and the blockage, the freezing of illicit assets that comes from the crimes that I described at the beginning, so crimes to the detriment of private person or companies. A large part of these cases are related to the crimes that I was talking of. So it's part of this huge number is devoted to those crimes, also swindling and cyber crimes, that are becoming a very important part of Eurojust workload. And so this tool, the regulation 2018, which actually was not thought and set on this consideration, as an important use for the protection of rights of normal people. And I would say that maybe the regulation could be called in another way, because the tools that are considered in the regulation are not only the freezing and the confiscation. Because if we think a bit thoroughly the content of the legal provision, what happens in the reality of our workload, we can say that there is third tool considered by the regulation, and which is more and more used is Article 29 of the regulation. So, restitution to the victims, compensation to victims before the conflict, which implies some problems and to have to be taken into account, and some lessons learned that we have received. I'm finishing. We have received from the practice at Eurojust. Theoretically, the regulation allows that, together with the freezing certificate, a judicial requesting authority can fill in section K of the certificate and ask for the immediate restitution, because although we talk also of compensation, this is a tool which is devoted only to restitution. Cannot be considered, in my opinion, for compensation, a direct restitution to the victim. At the same time, what we have learned from our experience is that if we want to be effective in supporting our national authority in order to restore the damages of our victims, some efforts in the judicial investigative practice have to be done on both sides. On the side of the requesting country in their proceeding, and in a limited way also on the side of the executing country. So, if we consider, and we should consider, although for instance for Italy, it is not also included in our code for criminal proceeding, that we have to take in due account since the beginning the right to restitution to the victims when it is clear that they have this right. Also, the focus of the investigation and the activities to be taken at national level have to consider that the affected third party abroad has to be taken into account, has to be allowed to enter into proceedings. Investigation have to be made on the way how they acquired the property. If there is any bona fide right on this property, so we have to consider, and also the executing country, when has to restitute the property, to return property to the affected person, according to Article 29, has to check this list that everything has been set in order to be sure that the property is not contested, that all the rights provided for by the Charter of Nice has been granted to the person concerned, both in the requesting country and in executing country. What is still missing, and I'm going to the end, in the regulation, the possibility for victims to ask the authority to issue a freezing certificate. No room for the victims, no possibilities for the victims to act as solicitors in this proceeding. This is a loophole that it is probably to be taken into account at national level when each country of the European Union will improve the directive 2024 on confiscation. Why? Because there is room in Article 18, although it is not well explained, but Article 18 is tailored in a way that, in my opinion, looks to be devoted to possible intervention, possible soliciting power that can be filed by the victim within the criminal proceeding of the requesting country. I know that I passed my time. It's time to leave, but I'm available for any clarification of any question. Also, furthermore, in the second part of the debate. Sorry? Yes, yes, yes. You can take my place.
Thank you, Mr. Ingangi, for your interesting presentation that shows that we also saw yesterday that step by step and probably not a good speed, but we are effectively progressing in the asset recovery question. Now, Madame Alibert from the Ministry of Justice of France has the floor.
Morning, everybody. I am Madeleine Alibert. I am a French magistrate working within the French Ministry of Justice. I am the head of the Comparative Law Office, which is located within the European and International Affairs Department of the Ministry. I would like first to thank warmly all people in charge of organizing this great international conference. And from my position, I really want to say that I'm very impressed by the quality of all the work which has been done to collect data on foreign laws and practices. And really the Recover database is a wonderful comparative law database. So really congratulations. Just to tell you briefly about my office, we complete every year around 100 research notes and studies in comparative law. And they are at the request mainly of the Minister of Justice, of the directorates of the ministry, and of courts. And these studies are designed to guide legislative reforms, especially by identifying good practice abroad. They help to support European and international negotiations as well, and they are aimed at informing judges and prosecutors within courts to know the content of foreign laws. We are also the French contact point and the administrator of the network for legislative cooperation between the Ministries of Justice of the EU. Today, I'm pleased to share with you the results of a comparative law study we have carried out at the request of the AGRASC. So my colleague from AGRASC will speak just after me. As for me, I will present you the results of this study about AMOS worldwide. We have researched 21 countries, but I will focus my presentation on AMOS from Canada, Ireland, Luxembourg, Moldova, Ukraine, and the United States. And these countries are not represented today.
Yes. Yeah.
Okay.
Right. So to conduct that research, we have used different resources. Of course, official dissemination of law websites and AMOS websites. We have used studies and reports from the European Commission and from the World Bank. And we have requested our liaison magistrates around the world because we have in France 18 liaison magistrates who cover between 50 and 60 countries, and they are a great help for comparative law. So I will give you a first look. You can see in these tables the names of the AMOs, the date of creation, and the status. So in Canada, we have this Property Management Directorate, which is part of Public Services and Procurement Canada. It is entitled to provide consultative and managerial services to law enforcement agencies in relation to seized or restrained property in connection with designated criminal offenses. It is entitled to dispose of seized property when the courts declare forfeiture, and it can share the proceeds from the sale of seized assets. In Ireland, we have the CAB. It was established in 1996 as an independent statutory multidisciplinary body, and in 2017, it has established an asset management office. So this office is made of members from the police, from the revenue commissioners, and from the Department of Social Protection. And the purpose of this AMO is to manage forfeited assets and realize their value, but only when it is appointed by the High Court to do so. The AMO in Luxembourg is the most recent one. It has been created in 2022. The law has created an AMO and an ARO. The AMO is under the authority of the Ministry of Justice, and the ARO has been established at the Economic and Financial section of the Public Prosecutor's Office for the Judicial District of Luxembourg. In Moldova, we have the Criminal Assets Recovery Agency, which is an autonomous specialized subdivision under the National Anti-Corruption Center. In Ukraine, we have the National Agency of Ukraine for finding, tracing, and management of assets derived from corruption and other crimes. It is a special governmental body. And in the US, it's quite special because we have the Department of Justice Asset Forfeiture Program, which involves 13 federal and local law enforcement agencies across the country. The money laundering and asset recovery section of the criminal department of the DOJ coordinates this program. And so within, we have the Marshal's Service, which serves as a primary custodian of seized and forfeited property. So we speak about all properties except firearms and ammunition. And this Marshal Service also disposes of forfeited property held in its custody. So now I'm going to explore with you the competencies of these AMOs. The first one is for certain AMOs, the identification of criminal assets. It's very specific to the Irish, the Ukrainian, and the Moldovan offices, which have proper competencies in that field. In Ireland, the CAB is an investigative authority and can request that courts issue search warrants and production orders, which order a person to make specific assets available to the CAB for the purposes of an investigation. In Ukraine, the AMO identifies, locates, and values assets at the request of an investigator, a public prosecutor, or an investigating judge. In Moldova, the Criminal Assets Recovery Agency has amongst its division the Special Investigation Department, who is responsible for taking measures to identify criminal assets. Otherwise, the AMOs don't have this specific competence, but they may assist upon their request police and judicial authorities. For instance, in Canada, prior to a seizure, the Seized Property Management Directorate can carry out an analysis of the financial viability of a seizure. Concerning the management of seized assets, which is the core task of AMOS, I will present some specific features of some AMOS. Concerning the management of movable and immovable assets, they may be subject to a value threshold or decided on the basis of the nature of the property concerned. So, for instance, in Luxembourg, management of all assets whose conservation is not necessary to establish the truth and which require acts of management for the conservation or valuation are in the field of the AMO. In Canada, the AMO is entitled to destroy goods that are illegal, dangerous, or without worth. Canada is very special above all because it has a very special competence concerning the management of seized businesses. So the AMO, in the Canadian AMO, after it does an inspection and preliminary appraisal of a business in the pre-seizure stage, then it's usually contracted out with industry and government for the services of appropriate professional for the best management approach. And the AMO is responsible for managing the business in accordance with the provisions of a restraint order. Concerning a preemptive sale, the Irish Asset Management Office can sell a perishable asset in advance, one that is depreciating rapidly, or when the cost of storage is disproportionate to the value of the asset. In Ukraine, a movable property may be put up for sale without the owner's consent if it is deteriorating rapidly, has lost value, or if the cost of storing is too high. The AMOs may be in charge of maintaining centralized registers. And I would like to speak about the CATS, which is quite notable. The CATS is the US Consolidated Asset Tracking System, which is managed by the Asset Forfeiture Management staff. CATS provide a consolidated asset forfeiture database for both administrative and judicial cases. So when an asset is entered into CATS, a standard identifier is applied to it, and it can be used by any of the 13 participating agencies of the program who wish to obtain the current status and processing details of the assets. The entire life cycle of the asset is available, and there is electronic mail and document generating software, which has been integrated into CATS to simplify correspondence and communication between all participating agencies. So concerning now the execution of confiscation decisions, I will just focus about Canada and Ireland. Concerning the Canadian disposal process, the AMO so concerning movable assets like cars, for instance, they are sold publicly or through auction to get fair market value. The money is shared according to the forfeited property sharing regulations, and real property like buildings, for instance, is disposed of using public services and procurement Canada realty services or private sector's realty brokerages. And after all the costs associated with the management of the seized assets are paid, the jurisdiction involved in the process share in the net proceeds. In concerning Ireland, I would like to speak about the Community Safety Fund. It was created in 2021 to allow proceeds of crime to be directed into community projects to support community safety. So, for instance, this could include activities concerning reducing reoffending or diverting vulnerable individuals away from engagement in criminal behavior. Concerning other competencies, we can say that all AMOs are invested with international missions. They all do international cooperation. Some of them, they have very important training missions, like the one in Ireland and Luxembourg. And some of them, like the one from Ukraine, can give operational assistance to police and judicial authorities. So this was a very brief overview of asset management offices worldwide, and maybe it may inspire all European countries who will have to set up such an AMO due to the new directive.
Thank you very much, and thank you also for adjusting to the schedule. And finally, we have with us Monsieur Arnaud de la Guiche, who is a public prosecutor detached in the Agrasc AMO in just ARO in France, or AMO.
It's a mix.
It's a mix. Okay. Thank you. You have the floor.
Well, good morning, everyone, and thank you for the invitation to this great conference. My name is Arnaud de la Guiche, and I am a French prosecutor working for the French Agrasc, which is kind of mix between an asset recovery office and an asset management office. And previously, I worked as a prosecutor at the French National Financial Prosecutor Office in Paris. So it will be a very short presentation, I promise, on some new legal tools we have in the matter of asset management. And we got inspiration from 2 other member states, 2 examples, inspiration from Italy and inspiration from the Netherlands. So I will give you some examples. Just a few words about the French agency. We are a public administrative body created in 2010. We have some powers of an ARO, but mainly we are an asset management office. We are under dual supervision, Ministry of Justice and Ministry of Public Accounts. We are directed by a member of the judiciary. Our general director, she was a former prosecutor in Paris and advisor to the French Prime Minister. We have a multidisciplinary staff. Nowadays, it's like 80, 90 employees at Agrasc, police officers, prosecutors, judges, law clerks, tax and customs officers. And we have an organization by asset classification. We have the financial department, the real estate department. I am the head of the real estate department of the agency. And we also have 8 regional units in the 8 main cities in France to provide like local support to courts and to prosecutor offices. This is mainly the organization, but you can check it on our website. So to talk about inspiration from the Netherlands, we have a new law on what we call interlocutory sales. So a sale of a seized asset, not a yet confiscated asset. In the previous legislation, we can get the authorization to sell an asset when it is not useful for truth and when it was likely to depreciate. And we studied what was done in other member states. And so we mainly studied the law in the Netherlands, and we got inspiration to convince our members of parliament. And now it is also possible when to have this sale of a seized asset when the asset requires a special handling or expertise, or where the storage, the maintenance costs are very high. So I think this tool is useful to get because it will, in my mind, enhance the MO's ability to manage very complex assets. Practical experience in this matter, we can also do it for a case of real estate. Upon request of a Dutch prosecutor, an asset manager from I won't say the name in Dutch, but the Netherlands AMO had contact with myself in Agrask in order to discuss sales of several seized buildings in the southwest of France, buildings targeted by a Netherlands freezing certificate. And so in this case, Agrask liaised with the French judge in charge of the case, support the judge in drafting the decision of the interlocutory sale authorization, and then we worked with the notary in order to supervise this sale. So this is an example of what we can do to manage an asset upon request of another member state. The second example is that 2 years ago we get inspiration from Italy about social reuse of confiscated building. We had a new law implemented in 2021, which is the use by a charity, a non-governmental organization, or a social housing organization for confiscated real estate. So, and the first case was the recognition by a French court, Tribunal Judiciaire de Paris, of an Italian confiscation order in an anti-mafia case. And now this building in the center, in a very nice place in the center of Paris, is used by a charity working to help women formerly victims of sexual exploitation. So it's an interesting case we had, and we got this inspiration from Italy 2 or 3 years ago. And in this case, it's my agency which is in charge of choosing the buildings devoted to social reuse. We issue a public call for expression of interest, and we get the expression of interest from the charities, from the foundation. We have it on our internet platform that you can have a look at on it. And we have a new provision also inspired by the Italian model. It's to also we can have a contract with local authorities that can be held responsible for management and use of confiscated buildings. And it's very useful, especially when there are housing projects. The local authority have to work with us on this project on confiscated buildings. So French state doesn't transfer the property of the building. It's a lease. Mainly it's a lease for free or with a very reasonable bill, but the cost of the maintenance is upon the beneficiary of the social reuse court order decision. This was the second example, and I will just conclude by giving you two examples of 2 sales of assets which we are very proud of. This year, we had the highest sale of confiscated real estate in France. It's the Château de la Garoupe. It's a mansion on the French Riviera, confiscated to Boris Berezovsky, who was a very old friend of Vladimir Putin. He was a Russian oligarch. And we sold this asset for 66 million euros to an Ukrainian guy. It's interesting to confiscate an asset to a Russian guy and to sell it to an Ukrainian guy. So no, he's Ukrainian and American. And everybody in this room know the buyer of this mansion because it is Mr. Yankum, is the founder of the WhatsApp application on your smartphone. So he bought this mansion for its holidays with his family. And this was a sale at the beginning of the year, and also another interesting sale in 2024 for 25 million euros. It's a building in Lyon. Lyon, it's the big city in France, was formerly owned by Rifat al-Assad. Rifat al-Assad is the uncle of Bashar al-Assad, president of Syria, and he was convicted in France for money laundering. So we confiscated the asset, for French court confiscated. À Grask, we made a call for interest to buy this building. And what is interesting is that under French law, the proceeds of the sale will be used for a restitution program to the benefit of Syrian population. So we won't give the money back directly to al-Assad family, because the nephew of Mr. Rifat al-Assad is still president of Syria, but we have to give back this money to French Ministry of Foreign Affairs in order to fund humanitarian program which are supposed to benefit the Syrian population. So this was the other example of managing and selling very complex assets I wanted to share with you. And this was my point. Thank you.
I think we can take 5 minutes of the lunch break. From Malta is the colleague? Okay. No. Sorry.
Generally, it's after the final confiscation, but in some cases, when there is, for example, a lack of maintenance of the asset, we can have an order from the court granting Agras authorization to sell the asset. But you have to prove that there is no maintenance and it's a building of public interest. For example, we have a very beautiful castle in Burgundy we are managing, but it's not for the moment. The conviction is not a final conviction because there is an appeal on the French Supreme Court. So we are entitled to manage the asset. We can have some management actions, or we can sell the asset when there is a public interest, because there are, for example, interesting monuments for France, so castles, things like that. Yeah, we have the headquarters in Paris, with for example, the real estate unit is in Paris and the international department in Paris. The main complex assets are supervised from Paris, but in the 8 main cities, we have a small Agrask unit composed of like 3 or 4 people working with the local courts in order to help them to go to see the judges and to get some assets and yeah.
So there are only one agency for in the criminal process, criminal file. After the execution of the confiscation, it's another institution, which is a fiscal institution. Yes, we support. They need to have an integrated system from the investigation phase until the final execution. We don't have final execution at Anabi, a fiscal one. And as a structure, now we create another 2 subdivision at Anabi in the center of Romania, because we need to extend our capacity and support other prosecutors and judges from other counties.
Okay, finally, we have with us Mr. Caruana from the Arrow of Malta.
Very much. First of all, I have right. Malta. In Malta, we are a small entity. We only started in late 2018. We are autonomous, but we fall under the Justice. Malta. We were designed under the Proceeds of Crime Act of Malta. We're still growing, and we're forming even more teams, such as an investigation team, moment, where they help as an example, provide how we operate. First, we get a court order to the ARB. Then our asset tracing does a desk-based research involving other entities, police, and then there is the asset management, who goes on site with evaluators, evaluates movable and non-movable properties, after which these are done to the director, who decides what not to release. Then a report is drafted, including all the on-sites, all the values, and this is presented to the court. After which there is the court decision, which might take years. And then if the confiscation
some of
Okay. I was wondering a question since the first intervention, then is my moment. Okay. Amos are not as well as French one, but are quite okay functioning. Spain, probably they have to see you more, but it's okay. But from my point of view of a prosecutor, don't you think, or every one of you think that in the light of the new directive, some more strong powers and investigating law enforcement powers should be given to the AROS? I explain. For me, in Spain, as an investigating prosecutor, ARO has not any utility because they only look the database. I can look the database myself. That doesn't give me any extra information that I already have. What I need is an investigating specialized unit police officer on the street, looking if effectively the people who is living in a house is related or not to the criminal, or searching in the webs, photographs in Instagram and so on to discover new assets. Then when the police give me that information, I directly ask to my colleague in whatever country with an AEO, and then I don't need an arrow for anything. And the reverse position is the same. When I receive an AEO, I charge to a specialized group in the police to look for the things, and once I think I have them, I issue to them, and then they issue a certificate or whatever. Then I don't really see the power of the arrow, a part of this new power of freezing and maybe confiscate, if they don't have really a law enforcement structure and law enforcement power. What do you think about it?
And we have the same problem. I stress that in Arrow, the activity of the national level is not very important. It's important at the level of cooperation, international cooperation. But my opinion, firstly, the project after the negotiation and before Parliament, the directive was at 60% that it is now. It was cut very intense. Some of the states didn't want a powerful arrow. Some of the states that also asked us to share the information as a proof, they didn't support Article 9 in the same time. That was my problem. But I want to stress out that before Article 5, which established the competence of arrows, we have Article 4. And Article 4, which is also in the chapter of tracing and identification, at the paragraph 3, established that where an investigation is initiated in a relation to a criminal offense that is liable to give rise of substantial economic benefits, asset tracing investigations pursuant to paragraph 1 shall be carried out immediately by competent authorities. And maybe the national authority, the national legislator, can establish the competence to Arrow to carry out this investigation of asset tracing. For example, we at Romanian Arrow, some cases where, for example, the Arrow Bureau can provide a study about the financial activity of some persons. There are also some projects like KleptoTrace, which are with Transcrime. They provide some database, and it's not only a database. These are a specific intelligence AI intelligence softs. They can provide a scheme. So maybe arrows will have a better competence in this matter to provide, in some big cases, a file that's the financial aspects from our point of view. But yes, it's in the competence of national legislator to establish that on behalf of Article 4, Paragraph 3.
Okay, thank you very much. Any other answer or questions? Yeah, Vania?
Focus investigation, the legislator put the example of the directive just fell apart, and what is it talking like a profession, like a practitioner. When we conduct criminal proceeding, of course, we can look register and obtain the information that the arrow might do. The problem is that in our legislation, the criminal liability focus my work and the investigator. The identification of the assets is not still the focus according to our legislation. So we contact with our RO and ask them, please look at the registers and obtain the information, because not because we can't, because I don't have time for it. Because my task is to obtain evidence and to put the bad guys in the jail at the end of the day. So I want to raise the question not only who has the competence, but to the government and to the your level. Let's define the focus of the criminal investigation. I would like to see both things, criminal liability and driving capacity, equal. And then let's see, do the work. I think that it's together. But the primary thing is define what is the scope of investigation. It's my
Yeah, it's the same situation in Spain, more or less. Yes.
Confiscation, the approach, no, that we in some case we have the trial for liability, and at the same time, in many cases, the separate but parallel proceeding in order to apply the preventive confiscation. And there is a specialized also tribunal with different competence. In theory, in some tribunal there isn't this specialized session, but in theory it must be in order, because the Italian legislator has is aware of the importance also of this parallel investigation in the asset, to verify if there are assets to confiscate. Also, credo, I suppose, a political culture decision, no choice. Important.
Yeah, probably. Okay, then that's it. Thank you very much, and have the break.